Good afternoon. Welcome to the Long Live Third Parties podcast. Free Press Media Press, Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Nader versus Keith, 385F3D729, Court of Appeal, 7th Circuit, 2004. Friends, we're going to talk about Ralph Nader again because his name keeps popping up again and again in these ballot access trials. Yes, Ralph Nader is suing once again. Good job, Ralph. We like to see that. In this case, Ralph Nader wanted to get on the ballot in Illinois for his campaign. But the district court here says, the district court denied him because he didn't get enough petitions signed. It says he needed 25,000 and he got 32,437. But this guy named Tully didn't like that, so he wanted the petition struck down. So the board ruled that 12,327 cases were not valid. So he didn't have enough. The court ruled that way, and thus they mention it here. Interestingly, in this case, unlike some other cases, Nader uses some philosophical arguments about the necessity of third parties. That's a good move. Another ploy. I'm not sure how persuasive that will be to judges, but it's persuasive to me and you, and maybe it will be persuasive to judges someday. He talks about how third parties started from how the third parties spun off from other parties, how the Republican Party was once the third party, and Progressive Party put ideas in, and even the Reform Party made a difference. I love that line of thought. Also here it discusses how the Illinois rules make it difficult for third parties and independents to get on the ballot in Illinois. The judges here say the Libertarian Party did it, so that means it's okay. As we discussed one of Nader's other cases in the 2004 election, it got me to think about Nader's campaign, because here he ran as an independent candidate, but in some states he ran as a third-party candidate. So it was a mix of independent and third parties. So I reviewed the Wikipedia article called Ralph Nader 2004 Presidential Campaign. It talked about how there was not just one or two third parties he ran with in some states, but there were several third parties he got on the ballot with. In a number of other states, he was an independent candidate. It says in this article, the Independent Party of Delaware, the Independence Party, the Reform Party, the Better Life / Populist Party, the Green Party, all worked in this campaign, as well as the states he did as independent. So that's a good strategy, if you ask me, to be an independent where you can and be a third-party candidate where you can. In fact, the article says that's why some people do it, because in some states, ballot access is easier for a third party than it is for an independent. So therefore, it helps your case to be a third party. So if that flexible strategy can help, I'm partial to running as a third-party candidate. Shall I run for election? If I ran for election, but given this train of thought, it might be wise to also run as independent, where it helps you get on the case. I suppose if it came down to it, whether it was an independent or nothing, you'd want to be an independent. The judges here make some, you could say, interesting arguments against third parties, but it has me scratching my head. Let's read what they say. It says, quote, "It doesn't follow from what we said about the importance of preserving opportunities for the entry of new parties into the political arena that it would be a good thing if there were no barriers at all to third-party candidates. A multiplication of parties would make our politics more ideological by reducing the influence of the median voter, who in a two-party system determines the outcome of most elections. And this could be a very bad thing. More mundanely, terminal voter confusion might ensue from having a multiplicity of presidential candidates on the ballot, for think of the confusion caused by the butterfly ballot used in Palm Beach County, Florida in the 2000 presidential election." End quote. What do you think about those arguments? They're talking about how ideological is a bad thing. We had a podcast episode about how once one of my two-party stellar friends said third parties are ideological and the two parties are pragmatic. So is ideological a bad thing? What do you think? Here it says this could be a very bad thing, but maybe it's not. Also, they continue some other arguments. They say, quote, "Less obviously, third-party candidates would themselves be harmed if there were no barriers to including such candidates on the ballot. It is to the Libertarian Party advantage that if Nader's challenges fails, its candidates will be the only independent candidate for the president on the ballot. If there were 98 independent candidates, none could hope for a non-trivial vote." End quote. I haven't come across an argument quite like this before. Maybe those of you out there have. It seems to be a head scratcher. Maybe you think there has some valid points in it. Would it help the Libertarian Party if there were more restrictions for ballot access? Would it, if there were 98 independent candidates, the Green says it's a myth, there are too many people running for office. So if 98 candidates got on the ballot, like they're talking about here, would that confuse people? If I have awareness of parties or the election, I might go into it knowing what I'm going to vote for. If I was a Libertarian Party candidate, I would vote for them no matter how many people were on the ballot. If I supported the Libertarian Party, I'd do that. If the first time you heard of any of the candidates was at the ballot, would it matter if there were 98 or 5 or 2? You were just going to be voting randomly anyways. They make one argument here that's peculiar to Illinois. They say Illinois has election fraud, and therefore we need to have these processes about challenging ballots and requiring verification to be extra strict in Illinois because Illinois has its history. Do you think Illinois should have different laws for ballot access than other states because of that? They cite a case where Oregon decided to do mail-in voting, but they say, quote, "What works in the state of Oregon doesn't necessarily work in Illinois, especially in the light of the colorful history of vote fraud we've seen." End quote. They mention Nader should have had a greater buffer. in the number of signatures. They say he should have had 37,000 or 40,000. While that's not a bad idea, I'm a big advocate of having buffers for everything. Buffers, extra money in the bank, extra time, extra space for everything. It's one of my main drives in life to give myself a buffer when I can. So that's not a bad idea. It's a good idea. It's a good strategy for signing ballot access petitions to have more to spare in case some are struck down. In another sense, I'm not sure if that alone should make this case less favorable to Ralph Nader here. They also mention Ralph Nader was better known than John Kerry, at least at some point in this election process. So the fact that he wasn't able to get enough signatures was a reflection on the campaign of Nader. So what do you think about that? What do you think? They did the math here. I haven't seen them do math like this in other cases where they say if they had 100 petition gatherers, each of them would only have to get four or five signatures each day over the 90-day period. So do you think that's persuasive? They also attacked Nader by saying he should have sued earlier because he sued so late it would make it difficult for the state to fix this if they wanted to do that. So ultimately they rule as follows. They say, quote, "But nothing is more common than for the denial of injunction to harm innocent non-parties, such as people who would like to vote for Nader, but unlike the two voter plaintiffs are not complicit in his decision on the timing of the suit. But there are innocents on the other side as well, namely the people who will be harmed if a last-minute injunction disrupts the presidential election in Illinois. And Nader supporters can, of course, write in votes for him in November. So all things considered, we cannot say that the district judge abused his discretion in refusing to issue a preliminary injunction." End quote. So do you think write-in votes are a valid alternative if you can't get... Obviously, if you don't get ballot access, it's what you do. But do you think that's a reasonable objection to denying someone their right to ballot access? They get write-in votes anyways. I don't. But hopefully you don't either. Write-in voting sounds like a good tactic you can use, but it doesn't mean you shouldn't have other options. So friends, Nader fought here. Hooray, hooray, he took a stand. So let me ask you this. How has Ralph Nader inspired you? Long live third parties. Goodbye.